Good afternoon. My name is Latrice Eggleston Williams, and I am a JM student. I will be explaining risk and contracts from the inventor's perspective. Here is our overview for today. We will talk about the agreement contract summary, which provides a scope of licensing and the sharing of intellectual property. We will review change requests for section 5, which includes 5 sections. One is a newly proposed section, a subsection of section 5, and we will also move to risk review of section 5, and we will provide recommendations with proposed changes that we will discuss in the risk, rationale and negotiations, and if we believe the deal would be successful. Here in the agreement contract summary, we are working with our inventor, who we are advocates for, Troy Greens-Gardner. We are working with him in contracting access to the intellectual property of Troy, the inventor, to the company Even Greener Toys and Games, which is owned by Hank through a license agreement. Our goal is to make sure that we protect the patent and utility and design of the game and the carbon footprint and calculator, which includes the characters in the game and the stories that are a part of it for our inventor, Troy, to the toy company, Even Greener Toys and Games, which we'll call Egg Tag. We want to make sure that the sub-licensees have a restriction to their use of the intellectual property of Troy Greens-Gardner, which includes green manufacturing, financial gains, and the proper presentations of the characters and games that are associated with the intellectual property. We know that we have to maintain compliance under Delaware law, as well as other states, as we will note that the territory defined in the scope of the license is within the United States, where the patents, trademarks, and copyrights are. We know that we've provided an option agreement that will give a $5,000 payment for confidential non-disclosure, agreements to Troy Greens-Gardner, to the company, from Troy Greens-Gardner to the company, to use his intellectual property of games, characters, and storylines. Here we know are several risks that we see in section 5. We know that our inventor, Troy, will lose the ability to negotiate and license with others under this option agreement, where he provides the opportunity of the company to work through an agreement to license his intellectual property. And we know that we take the risk for the inventor, as the company can either execute or terminate their agreement for discretionary authority, or vice versa. We could also do the same and not particularly allow the company to be only a sole negotiator. So we take on that risk, as well as the company makes a $5,000 sort of payment as a way of providing non-disclosure and confidentiality with the intellectual property until such time as a full agreement can be reached. And so we also, as the inventor, lose the ability to negotiate and license with others, and we use the opportunity to make additional funding or money. In any event that we don't breach the agreement, we will maintain that right in the case, or the $5,000 in case the company does lose that. The inventor also loses a sense of their direct intellectual property when providing a sublease to the company, who will sublease to other entities. And we do gain some closure in that we have to approve who those subleasees will be. Here are the changes that we do request in section 5 as it currently reads. We know that in section 5.01, where the inventor's grant of exclusive license, we want to delete all of and also insert information pertaining to the clauses in Exhibit A. And so we want to make sure that our inventor's license is maintained appropriately, and that the inventor also has their rights of intellectual property in general maintained overall, which is a new version or subsection that we input in 5.02. And we also have no changes to section 5.03, which gives the company the right to sublicense. But we do want to modify the verb tense in section 5.04, which is the process in which the sublicense approval will happen with the company. And then we have the right as the inventor to ensure that we give consent to those who are given a sublicense, and we have no changes that we want to provide in that section. So here are the general recommendations. We request all necessary changes to the contract that we just discussed. We want to make sure that both the inventor and the company have a balanced sense of control. While we want to surely protect the inventor's intellectual property, but we want to make sure that the inventor and the company both share in the potential risk of losing profits. We also want to ensure that the deal allows the inventor to provide their intellectual property licenses to the company over a length of time, and it yields control of earnings as we negotiate under the control of the company who will provide the sub-licenses under the consent of the inventor. And we believe that this will balance our risk, both the inventor and the company. And as such, if these changes are made, we believe that we can successfully strike a deal that complements both the needs and desires of both the inventor and the company. The references we used were Toy Game and License Agreement Scenario, Model 2 and 3, the final revised, the Toy and Game Option Agreement, final revised, and we, of course, used Tina Stark's Drafting Contracts, How and Why Lawyers Do What They Do as an overall guidance with the Scream Risk Assessment. If you have any questions or need additional information, please feel free to contact Latrice Eggleston Williams, myself, an LM student. I provided you my email address, latrice.eggleston.williams@emory.edu, or you can also reach me by phone at 312-560-8033. Thank you.